All right.
Oh, Your Honor, this is a motion to continue the briefing schedule. As you notice, I talked to the state ahead before filing the motion, and the state told me to put no opposition on it. However, I did ask for a hearing so we can set some dates. The two reasons that I needed a continuance on it was, number one, the guilty plea agreements, the one in front of you, and then I looked at one of his other ones in another case. The attorney's signature is a big R. So his attorney at the time has no R's in her signature. I've contacted his previous attorney, Ross, as well as Amy. Ross has not gotten back to me at all. I realize it's the holidays. Amy did reply to me in an email saying, hey, I'm in trial right now. And this was about a week and a half ago. I'm in trial right now, but let's talk with each other later. I responded to my particular question in email. I've not heard back from her. The bigger issue
Is that the one in the other case?
no.
It's the one in this case?
There's an R on both the cases. The GPA that you took, as well as the GPA that was taken in his other case are signed. I know.
Do you need me to check and see who his attorney of record was at the time?
I know who
Oh,
his attorney of record was. His attorney of record was Amy when he was canvassed. When you canvassed him,
Okay.
his attorney was Amy. But when I'm going through the motion to set aside the plea, one of the things I noticed, while quite frankly not even looking for it, is they're both signed. The attorney that signed it is an R, which is just like Amy has no R's in her signature. I found things by Ross that were filed because I have Odyssey that are signed with an R. They look a little bit of a different of an R. I could not find anything signed by Amy to compare to her signature. Like I say, I reached out to both of them. I would hopefully try again, maybe one time this week, maybe 2 times this week to politely reach out to them. And if for some reason they don't get back to me, not saying they won't, then I can ask you next week to say, hey, can you tell them to show up here so we can know who signed this thing? The other more important thing is, he was sent to competency court. He was deemed competent, but both of the people who reviewed him independently had concerns with his psychiatric health. One said bipolar, the other said confusions and some other things. Well, I've reached out. He has executed a HIPAA request form to Southern District of Nevada because he has informed me that he has attended there many times for some mental health issues, which arguably could be a reason to set aside the guilty plea agreement. I am instead of just a 2 30-minute guys interviewing him, I would love to get his more medical history to present to you when we file that. Those are the two issues. Now, for particular dates, his motion for changing custody status, I believe, is going to be heard next week. The motion is done. I need to proofread it before I file it, quite frankly. But I hope, I'm a horrible writer, so I never file things until I proofread it. So that could serve as a status check next week, whenever the hearing is, assuming it is next week. If not, to be safe, maybe we set one for 2 weeks from now. Does that all make sense?
Okay,
so a lot in a little bit of time.
You haven't filed the motion to address custody status.
I have
So you anticipate filing that when?
probably today.
Okay.
I
and
don't
then-
see why I went today unless I get in a car accident.
All right, and then you should get a hearing when?
I'm guessing usually custody status is addressed pretty quickly.
So maybe a week?
That's what I'm thinking.
All right, so maybe on the 12th.
Here's my question. Can we just wait till we filed it and then schedule the hearing for that? And then there's a couple of other things that I wanted to be heard about if the court's
Okay.
ready for me. Reaching out to those attorneys and asking them questions and whether or not they get back to him is one thing, but demanding that they come into court in the absence of an evidentiary hearing with an actual filed motion is another entirely. So if they don't respond to him and he has an allegation that these attorneys somehow switched or whatever, that's his business to bring up in a motion. And then if the court orders an evidentiary hearing, then we can bring them in under oath and then they can answer some questions. But in addition, and I just need to point out for the record, the court in both departments canvassed this defendant if he went over the agreements with his attorneys and he said yes. And he had 2 attorneys during that time or several attorneys during that time. So I think that's a thing that we can hash out in writing before we just demand people come in here and respond. In terms of the timeline for the motion for an OR, I think you should file it and then we can address it when it's on calendar. And then in resetting the briefing schedule for the motion to withdraw a plea, those medical records could take a minute. So if the court wants to do a status check to see where he's at and getting those, that's fine. Or if you just want to set a briefing schedule out in advance to give him time to get those, that's fine. But I think we just need to take one piece at a time.
I agree with her three major points. Quite frankly, I wasn't asking to be scheduled right now for the OR hearing. It was more of just letting you know that we'll probably be back here next week anyway, if that's a status check was. I'm not asking you to force any attorney to come into court. I've seen before when they're like, hey, why aren't you responding? I would love an evidentiary hearing. That is the goal of a motion to set aside guilty plea agreement. So yeah, I'm going to agree with that if they do not reply to me in 2 times. But again, the most important thing is those documents, and I don't think anyone wants to do 2 separate evidentiary hearings, one on what the heck went on here with, canvassing him and the going over the guilty plea agreement. And then, well, he's bipolar. Why wasn't we canvassed more about what medicines he was on or not on at the time? Does that make sense?
Mhm.
Thank you. I'm talking very
Okay,
quick.
so what I'm trying to figure out is when are we gonna set the briefing schedule? Do you want a status check to set the briefing schedule once you get a handle? Because, like you said, you're not a civil attorney, so you're not really familiar with how hard it is to get, well,
No, I do civil also, Your Honor.
oh, okay,
And
I
know
apologize.
how, like, some, when I do PI.
Medical
I do
records can
some,
be difficult.
They'll get it to you within 2 days, and then some will take 90
Right.
days. Yeah, I know this.
Well, then let's how about we keep the hearing on the 12th instead of it being the argument on the motion to withdraw the plea? I'll vacate that and we'll set a status check on that at that time to set a briefing schedule. And whenever master calendar schedules the hearing on the motion to change custody, that'll be when master calendar sets it. Does that
all
sound
sounds
okay,
correct.
State?
That's perfect. Thank you.
Okay.
Sorry.
All right, so we'll be back here on the 12th to work on the briefing schedule, unless you want to push it out farther than that to see if you've heard from the.
Well, because there's a bit of providing us to have something, so I would say schedule out further, so there's no chance.
No, I agree. It's not going to happen on the 12th. We know this, but at least I can see if the attorneys got back to me and I can reach out to Southern Health saying, how long is this going
Right,
to take?
so why am I gonna show up?
Do you want your presence waived? Is that okay with everyone? Okay, all right, so the status check on the 12th, the defendant's presence is waived, because we're just gonna be talking schedules. Okay,
As far as goes to custody status, I mean, May 23rd, I had no notice, no attorney, and there was no reason for it. So I'm just saying, every day I'm in here, it's violating my rights, and the DA knows that. And if I could get this passed over to my parents, it's just the psych evals, because they keep asking,
you can give it to your attorney.
I keep asking him to send it to my parents and he won't do it. He won't respond to my parents. I can't call him because his phone rings too much, where if I call from the jail, he just hangs up on me.
Okay, I'm not gonna get in the middle of this. So,
What am I supposed to do?
don't tell me the reason, but is there some reason you're not giving that to his parents that you feel is legally compelling?
Want me to step outside?
I will.
Just yes or
email
no?
those to his parents.
Okay,
But I don't want to talk to
Thank you,
them
State.
about the case for other reasons.
okay.
And a lot of times they go hand in hand.
I get permission though, and it's not just that. I can't get any documents from him. He said he was gonna give it 5 months ago. I can't get anything.
Okay, so we're not gonna get into that right now. It sounds like if you could give that to him and he can send it over to your parents, or they can come pick it up at his office or whatever they want to do. And we are gonna be back on the 12th just to set a briefing schedule, and your presence is waived, Mr. Bellisario. And then we'll see when the motion to change custody status is.
Thank you, Your Honor.
All right, thank you, everyone.